Welcome to the Supreme Court, where we are resuming the hearing of the Heathrow Airport appeal. We're currently hearing submissions on behalf of an environmental organisation, Plan B Earth, presented by its director, Mr. Tim Crossland. So I'll invite Mr. Crossland now to resume his submissions.
Thank you, my lord. My lords and ladies, just before lunch, we were looking at some of the evidence from government departments about the role played by the Paris temperature limit in government policy. We've just been looking at the government's 25-year plan, which said that compliance with the Paris Agreement was vital for future environmental security, and the UK would be using its diplomacy to ensure that that limit was met. If we can turn now to the core bundle 1579, we see here evidence about how the Foreign and Commonwealth Office was supporting that policy. A question is asked: what diplomatic steps is the department taking to support implementation of the Paris Agreement? And the response from Mark Fields, the Foreign Office Minister: climate change is an existential threat, but also an opportunity to drive a global clean economy revolution. Our diplomats and climate envoy are working with BEIs and international partners to ensure international implementation of the Paris Agreement commitments and project UK leadership, including our clean growth strategy. So we've seen the Prime Minister, we've seen BEIs, we've seen the Foreign Office. Let's look at the Department of Transport. And we can see the Statement of Fact and Issues, paragraph 40. There's a reference here to the Department of Transport's UK aviation forecasts. And you'll see a quote taken from that: the forecasts of UK aviation CO2 emissions should be interpreted within the context of broader UK and international climate change policy. And that, of course, is because it's an international sector. The Climate Change Act commits the UK government by law to reducing greenhouse gas emissions by at least 80% by 2050. But as we know, it excludes aviation. The UK has also signed up to the Paris Agreement, which aims to hold the increase in global temperature to well below 2 degrees. So that's the Department of Transport itself saying when we look at aviation emissions, we must look at it in the light of the Paris Agreement goal.
Mr. Crossland, I'm sorry to interrupt you, but I've just received a message from our engineers asking me to adjourn the hearing briefly. It may be for some technical problem. So I'm sorry, we'll have to adjourn for a minute or two. I suggest that people simply switch off video and audio feeds in the meantime, and they'll be contacted as soon as we're able to resume.
Okay, thank you.
I'm sorry about the technical difficulties we've been experiencing. I think, Mr. Crossland, before I ask you to resume, it might just be worth making sure that Lord Legate is aware that you had referred us to MS 1579, where there is an answer given by a Foreign Office Minister to a parliamentary question relating to the Foreign Office's step to support the implementation of the Paris Agreement.
Indeed, my lord, thank you. And I can see my voice is back. It's a relief. And so following that, the statement from the Foreign and Commonwealth Office that talked about the efforts, the diplomatic efforts the FCO were taking to ensure global support for the Paris temperature limit, We then looked at paragraph 40 of the Statement of Facts and Issues, and that is the Department of Transport's own aviation forecasts that say forecasts of UK aviation emissions should be interpreted within the context of broader UK and international climate change policy, and then make specific reference to the Paris Agreement and the Paris temperature limit. So that is the Department of Transport saying that is the proper frame to look at this international sector of aviation, the Paris temperature limit. So, my lords and lady, in our submission, if you look at the accumulation of evidence, the government's explicit climate change policy, which is the clean growth strategy, which emphasises on every page the commitment to the Paris temperature limit, the Prime Minister, the Minister, the explanation of why that limit has been adopted. Look at all other government departments, the Department of Transport, the Foreign and Commonwealth Office. This is all branches of government, all hands to the pump, saying we've got this single goal, which is vital to our future environmental security, which is implementation of that Paris limit. And that depends not only on our own emissions, but being able to influence other countries to do the same thing, because we're just as affected by their emissions as our own. Lord Anderson has only one response to this, and this was his submission yesterday, that actually taking into account the Paris temperature limit would have been a purely formulaic exercise, wouldn't have taken us anywhere, and if only the Secretary of State had had the good sense to say, oh, I've thought about the Paris temperature limit, that would have served, and there would have been nothing to argue about. That's completely wrong. And the easiest way to see that is if we turn to the paper by David Lee, which was published by the Department of Transport in December 2018 as part of a consultation on aviation strategy. It's in the core bundle, page 1832. You'll see this is aviation and the Paris temperature, the Paris Agreement. And in that first paragraph, he says long-term goals for CO2 emissions from total and international global aviation are considered here in the context of the Paris Agreement, which set out a goal to hold increases in global mean surface temperature to well below 2, above pre-industrial levels, and to pursue efforts to limit this increase to 1.5. And then he explains how this isn't simply an aspiration. In order to put it into practice, a scientifically based cumulative carbon budget approach is being taken, where cumulative anthropogenic CO2 released scales with the global mean surface temperature response. I mean, it's slightly technical language, but he's saying, well, we can operationalize this, we can translate it. And then on the last paragraph of that page, he says this: therefore, for 1.5 degrees global scenarios, any continued emissions of CO2 from aviation using fossil fuels beyond around 2050 will be inconsistent with the Paris Agreement goals in the absence of extra measures, or alternatively correspondingly increase negative emissions. My lords and ladies, if we turn back to the Department of Transport's own projection for carbon emissions, we can see very clearly why application of the Paris temperature limit would have raised serious questions for the AMPS, and that's at 1481. We've already seen this graph, but it's useful to look at it again in this context. The Department of Transport's evidence is saying for consistency with Paris, aviation emissions will need to be 0 by 2050 in the absence of extra measures. It's a very specific, concrete statement. we look at the Department of Transport's projections on the baseline scenario, they're estimating 37 million tonnes of carbon dioxide just from UK aviation by 2050. And on the basis of the third runway, far from going down, of course, those emissions increase with a central estimate of around 40 million tonnes of carbon dioxide from UK aviation by 2050. My lords and ladies, we do not say, because we don't need to say, that the two positions are necessarily inconsistent. That 40 million tonnes of CO2 from UK aviation in 2050 is inconsistent with the Paris temperature limit, which, according to the Department of Transport's own evidence, implies zero CO2 emissions globally from aviation by 2050. Maybe the Secretary of State could have explained what additional measures he would have taken to reconcile those seemingly contradictory positions. But the fact is that he didn't. He didn't do that because he didn't even take into account the Paris temperature limit. Instead, he applied the old, inadequate 2-degree limit. Had he asked himself the question, then no doubt he could have obtained Mr. Lee's advice ahead of the designation of the AMPS. But in reality, he didn't need to wait for Mr. Lee's advice at all, because by June 2018, the position was already clear from numerous other sources. And first we come to the CCC's report of 2016. This was the major bit of work they did on the implications of the Paris Agreement. And maybe the easiest way to see this is to go to the Court of Appeal judgment, which produces the relevant excerpts at paragraphs 207 and 208. That's pages 291 to 292 of the core bundle. And at paragraph 207, they say, on page 9 of the CCC's report, it was said that to stay close to 1.5 degrees Celsius, which is the aim of the Paris Agreement, CO2 emissions would need to reach net zero by the 2040s. Reference was made to Table 1, which was on the same page. In other words, a clear statement from the Committee on Climate Change. You're serious about the 1.5, aviation global emissions have to come down to zero soon. And then at paragraph 208, you'll see, I think it's quite a long paragraph. So just on the next page, across from 208, on the opposite page, the second paragraph down, this is specific to the UK. Global paths to keep close to 1.5 at the upper end of the ambition in the Paris Agreement imply UK reduction of at least 90% below 1990 levels by 2050, and potentially more ambitious efforts over the timescale of existing carbon budgets. So that was the Committee on Climate Change's position in 2016. Next, we can look at Statement of Facts and Issues, paragraphs 57 to 58. This is the draft IPCC report that was in the hands of government between January and February of 2018, again ahead of the AMPS. And the IPCC, the leading international advisory body to governments on the science of climate change, it stated that in model pathways, with no or limited overshoot of 1.5, global net anthropogenic CO2 emissions reach net zero around 2050. In other words, everybody's emissions need to reach net zero by around 2050. and my lords and ladies will remember the advice of the Committee on Climate Change back in 2016. It was, don't set the new target now. Let's wait for the IPCC's report in 2018. That's when we will have a better evidential base. We know that report is coming because it's been commissioned by the parties to the Paris Agreement. Having committed to the 1.5, we now need to know what that means. And the IPCC make it clear. And then we come to the government's own clean growth strategy. And the relevant part is summarised at SFI paragraph 49, 78 of the core bundle. So this is official government policy. And this is proper CCC advice. The CCC advised that the UK's fair contribution to the Paris Agreement should include measures to maintain flexibility to go further on the UK targets. In other words, what the CCC is saying is we know we're going to have to go further. We want to wait for the IPCC's advice before we set those targets specifically. In the meantime, you need to maintain the headroom to go further, because otherwise we won't be able to. Otherwise, you will preclude and exclude the more ambitious, more stringent target that we know is coming. Turn now, please, to the core bundle 1577. This is the vote of the European Parliament from January 2018, and you'll see this is again, it's a response in reality to the IPCC report. You go along, please, to amendments 6A and 6B. Don't need to worry about the complexities of European legislation here. This isn't the point. But 6A, the Paris Agreement substantially increased the level of global ambition on climate change mitigation. And it mentions the Paris temperature limit. The Union needs to prepare for much deeper and faster cuts in emissions than previously foreseen. At the same time, such reductions are feasible at a lower cost than previously assessed, given the pace of development and deployment of renewable technologies. And then at 6B, Amendment 6B, in line with the aim of the Paris Agreement to achieve a balance between anthropogenic emissions by sources and removals of greenhouse gases by sinks in the second half of the century, the Union should aim on an equitable basis to reach net zero emissions domestically by 2050, followed by a period of negative emissions. As I say, the issue here is not the legal status of the European Parliament's vote. It's simply to make the point that by 2018, it was perfectly possible to translate that temperature limit into emission targets. And there was a consensus, as we see it emerging, that globally CO2 emissions need to reach net zero by 2050. And then, and this is a really crucial piece of evidence, on 1st of May 2018, and page 1587 of the core bundle, the Right Honourable Claire Perry MP, speaking on behalf of the government as Energy Minister, she states directly to Parliament that it was the government's specific policy to decarbonise the UK economy by 2050. We see that the bottom of the 5th paragraph down on the right-hand side. Claire Perry says, he will also know that we're the first developed nation to have said that we want to understand how we will get to a zero carbon economy in 2050. We were the first country in the world to ask how we will get to a decarbonised economy in 2050, and I would hope that we would enjoy cross-party support for something so vital. So here we have a minister on behalf of the government informing Parliament that it's the government's specific policy intention to reach net zero by 2050. Nothing could be more clear. My Lords, Lord Anderson emphasises the text in the Paris Agreement, and my Lord Leggatt.
A bit more, if you, sorry, I'd just like you, Mr. Croston, to focus a bit more, if you would, on what amounts to policy or a statement of policy for the purpose of the 5.8 of the Act. I mean, do you say that every time in Parliament a minister makes a statement saying something is government policy, then that has to be explained as to why the APNS is consistent with that? So does it mean that the people preparing and advising on the preparation of the APNS have to trawl through Hansard and find every time a minister has made a statement and then explain why the policy statement is consistent with that? If not, then which ministerial statements in Parliament count as policy statements and which don't?
Well, of course, it's not every single statement. What I think we're seeing here is a cumulative pattern of evidence that shows us that every government department is expressing its commitment for the Paris temperature limit. There is no evidence whatsoever that by 2018, the 2-degree limit, which was used by the Secretary of State, remains government policy. Everybody's saying that that has been rejected. So the obligation on the Secretary of State under Section 5.8 is to consider the AMPS in the light of government policy on climate change. What he's done in purporting to exercise or satisfy that statutory requirement is he's considered the AMPS against the historic 2-degree target.
And I know all that, but what does he have to do to identify government policy for the purpose of carrying out the obligation? What materials does he have to look at? Everything said in Parliament, or where does he find what are the sources of government policy that are relevant?
Well, my Lords, for a start, the Clean Growth Strategy, which is explicitly government policy relating to climate change. That is government policy published under the Climate Change Act. And as we've seen on every page, that emphasises the government's commitment to the Paris temperature limit and explains why the 2-degree limit has been abandoned. So there's no doubt that that is government policy, because it formally is. It's published under the Climate Change Act itself. So all these other statements, they're just reinforcing that position. What we say is that, of course, the exercise shouldn't be impractical or unrealistic, but by 2018, everybody knew that a more stringent target was coming. That's not something we're saying with the benefit of hindsight. This was, there's a whole history here. We've seen the Committee on Climate Change saying we need a review of the targets. We've seen the government saying, yes, we're commissioning this review. We have the minister.
What that is saying, surely, is we're going to have to formulate a new policy that will take account of that target.
Well, it's saying more than that, isn't it? Because the Climate Change Committee have said in order to make headroom for that new target that's coming, we need to create the flexibility to go further than existing targets. That's clear advice to the government that's in the Clean Growth Strategy. It's essential that we do that. Otherwise, we'll be shutting the stable door after the horse has bolted. It'll be too late.
Thank you.
So, my Lord and Lady, at every level, we've seen how it was possible to translate that global temperature limit into something practical. At the global level, the IPCC had said it means global net zero emissions by 2050. At the EU level, the European Parliament had said within the EU, it means net zero emissions by 2050. Claire Perry, the energy minister, had said the same thing. This wasn't random statements being thrown out. It was a consistent pattern from the global to the national. And the right on Chris Grayling MP, the Secretary of State at the time, he simply buried his head in the sand. He proceeded as if there had been no significant changes to government policy in relation to climate change since 2008, when in fact the intervening decade had been a period of seismic and profound change. As we've seen from the Clean Growth Strategy, the landmark agreement simply wasn't correct to proceed on the basis everything was just as it had been in 2008. It quite clearly wasn't. My lords and ladies, one further point on this issue. For the purposes of Section 5A, the critical question is not necessarily what the Committee on Climate Change's advice was. The question is what government policy was. And we've already seen in relation to the planning assumption that there could be a gap between the two things. In other words, the committee might have recommended something to the government, but the government had decided not to take on that recommendation. At the time of the designation, the government had in fact already communicated to the CCC its policy intent to reach net zero by 2050 in accordance with this emerging international consensus. They sought the CCC's advice on how to get there, and as we know, because history relates, that's the advice the CCC ultimately give to the government, and that's the law that comes into force. This was all very predictable in June 2018. The trajectory was already very clear. And my lords and ladies, we say this is a good illustration of why Parliament was wise in 2008 to legislate Section 5.8 in precisely the terms that it did. The Planning Act, which was prepared and published simultaneously with the Climate Change Act in 2008, was deliberately interlocking. It could easily have confined the analysis in Section 5.8 to the carbon target in the Climate Change Act Section 1 if that's what it had wanted to do. But it's clear that it didn't do so. It didn't say assess the AMPS against the climate change target in CCA Section 1. Instead, the requirement is on the Secretary of State to look at government policy more broadly. And as the Court of Appeal rightly said at paragraph 224 of their judgment, that's 297 of the core bundle. In particular, we can find no warrant in the legislation for limiting the phrase government policy to mean only the legal requirements of the Climate Change Act. The concept of policy is necessarily broader than legislation. By June 2018, the time of the designation, it was clear that a new, more stringent domestic emissions reduction target was on its way, alongside the government's commitment to the Paris Agreement. On Lord Anderson's case, which is that it would have been unlawful to consider the Paris Agreements and associated policy developments under Section 5A because it wasn't government policy, the Secretary of State would have been obliged to ignore what was in reality plainly relevant. On that interpretation of Section 5.8, the designation of national policy statements would risk becoming an unseemly race to beat the legislative clock. You can see how the government might have knowledge that a new target was coming in, but if we're not allowed to take account of that knowledge, if we're not allowed to listen to what we know is coming quickly, let's sign off the national policy statement before the law changes. And that can't be in anybody's interest, that approach, that sort of deliberate blinkering of what's coming. Such an interpretation in our submission does violence to the clear wording of section 5.8. The natural meaning of the word policy implies intention, government policy and the intention of the executive, which should be distinguished from the will of Parliament, which is the will of the legislature.
Mr. Crossland, I wonder if I can pick you up on your last point. You say that you might end up with an unseemly race to beat a legislative change. As I understand Mr. Wolf's submission, he accepts that the policy statement as written caters for a legislative change in relation to the carbon emissions target for 2050. Do you take the same view or do you take a different view?
Our view is that the Secretary of State was under a clear obligation by virtue of section 5.8 to look at government policy at the time, not just law. And government policy, as we've seen, was already by June 2018 to do everything possible to secure implementation of the Paris temperature limit. So we do, that is a different view.
Well, I'm not sure if, with respect, that answers the question I posed. It's paragraph 5.82 in the statement, and I understand Mr. Wolf's position to be that requires a developer coming forward for a DCO to meet the standards set by government at the time of the DCO. Do you take a different view of that meaning?
No, we don't. I think that is correct. What our position on the DCO is simply that that doesn't cure a failing at the AMPS stage. It's as simple as that.
No, well, I just wanted to get your position on that.
Of course.
Thank you very much.
So, my Lords and Ladies, we now do come and bring into focus the position of the CCC advice, recognising that distinction between CCC advice and government policy. And it is important to be clear on what the CCC's advice was at the time of the designation. Lord Anderson places great weight on the legal documents submitted by the CCC in the course of legal proceedings concerning Plan B. And we can see that document at page 1811 of the core bundle. And if I may, I can provide some context around this. So you'll see in the chronology, Plan B commenced legal proceedings in December 2017, saying it's about time we brought our statutory target into line with the Paris Agreement. In January 2018, the CCC effectively agree with us. They say to the government, we need a review of the 2050 target. That's in their response to the Clean Growth Strategy, January 2018. And we then have a commission hearing in the judicial review, and the CCC don't appear, and nor do they make any submissions. And Nicola Davis, Justice Nicola Davis, as she was at the time, she says, well, this isn't satisfactory. Why haven't we got the CCC here? She adjourns the permission hearing, and you'll see this in, it's page 198 of the Court of Appeal's judgment. That's 288 of the core bundle. She orders the Committee on Climate Change to produce a document setting out their position for the court. And if you look at the bundle 1811, the document itself, you'll see it's a legal submission. It's a little bit unusual in that it's not signed and it's not dated, but we assume it was prepared by Richard Gordon QC, who was counsel for the Committee on Climate Change at the time. And what I think we see in the Court of Appeal's judgment initially is just a little bit of an element of scepticism that this legal submission prepared by Richard Gordon was guiding the Secretary of State's approach to how to assess the ANPS. This is April 2018. The assessment of the carbon impact of the ANPS has been going on since the Airports Commission report in 2015. By this stage, we're nearly there. We're nearly at the designation. We've seen from Caroline Lowe that all the Secretary of State had done was use the same scenarios used by the Airports Commission, the carbon cap scenario, the carbon traded scenario based on 2 degrees. There's just an element of scepticism, maybe, that this legal submission, where Richard Gordon uses this phrase potentially consistent, that, aha, this changes everything. This changes our whole assessment and our approach to the ANPS. And I think we see that paragraph 200 of the Court of Appeal's judgment. The court notes our submissions, submitted that this wasn't evidence. Still less was it an up-to-date statement of the Committee on Climate Change's advice to the Secretary of State. Rather, it was no more than a cross-reference back to the Committee of Climate Change's report of 2016, merely the interpretation of one person, because the Climate Committee's actual report of 2016 doesn't anywhere say that the UK's carbon target is consistent with the Paris Agreement. All it says is it's consistent with a range of temperature outcomes, because none of this is certain, and all of it is probabilities. You know, a 50% probability of keeping warming under 2 degrees, maybe a 20% probability of keeping it under 1.5 degrees, potentially consistent, but all that really means is it might be consistent, it might not be consistent. And that's not really a very powerful basis for the approach you take to the ANPS. Why not instead follow the actual advice to the government from the Committee on Climate Change? This is proper advice given directly by the committee to the government, which was UK emissions are going to have to reduce to 90% to align to the 1.5 degrees. We've seen that already. Global emissions need to reach net zero by 2040, and it is essential in the meantime that we maintain headroom to go further in our targets. That was the actual advice given by the committee. This is simply a legal submission from April 2018, and that is what the interpretation that we place on the Court of Appeal's judgment. We say they were quite rightly a little sceptical. My Lady Black.
Can I just be sure about the phrase potentially consistent? I thought you just a moment ago suggested that it may have been Council's phrase, but it wasn't, was it? It was the phrase that was used in the report by the CCC. We can see it at page 16 of their report.
They don't say potentially consistent with the Paris Agreement.
No, they don't.
They say potentially consistent with a range of different temperatures, which would be true of any emissions reduction target. That's with respect to the committee, it's really a statement of the obvious.
Right.
Any emissions trajectory is consistent to different levels of probability with a number of different temperature outcomes, but they definitely do not say in October 2016, consistent with the Paris Agreement. What they say in 2016 is the Paris Agreement implies a higher level of ambition, and for consistency with 1.5, UK emissions would need to be more like 90% reduction by 2050. So that's, inconsistent with them saying it's consistent.
Okay, thank you.
So yes, what we say, my lords and lady, if the Secretary of State were genuinely concerned about the Climate Change Committee's advice, he would have spent more time looking at that detailed report from 2016, and just for references again, in the Court of Appeal judgment, paragraph 207, this is for 1.5, need to reach net zero by the 2040s, paragraph 208, we've just looked at it, 90% reductions, and just as importantly, and we've seen this before, the clean growth strategy, summarised paragraph 49 of the Statement of Facts and Issues, 78 of the core bundle. The CCC advised the government UK's fair contribution to the Paris Agreement should include measures to maintain flexibility to go further than the UK targets. It's quite clear if you look at their actual advice, they're not saying everything is fine, just keep on autopilot. It's the opposite of what they're saying. So, my lords, even if the only bit of advice the Secretary of State had taken was that advice, that clear advice from the committee, already that would have created questions around the AMPS and the framing of it, because as we've seen from the Department of Transport's own projections, the ANPS implied, and the third runway implied, emissions in excess of the planning assumption that the Committee on Climate Change had recommended to the government. So that is inconsistent with the committee's advice that you need to create flexibility to go further by doing better than the current targets. And because the Secretary of State has ignored that advice, he simply hasn't addressed the question. Nowhere does he ask himself, how do we create the flexibility to go further? The obvious common sense question for the Secretary of State to have asked, given all that was happening in this area, is what's it going to mean for the AMPS when we introduce a more stringent target? How will this support the direction of travel that we all know that we're going in? How will it support the Committee on Climate Change's advice that we need to maintain the flexibility to go further? Finally, my lords and lady, and on this section, just to highlight one further difficulty for Lord Anderson in claiming the Secretary of State was simply relying on the Climate Change Committee's advice. And that's, again, the letter from Lord Deben and Baroness Brown, Chair and Deputy Chair of the Climate Change Committee. It's the core bundle 1625. The Climate Change Committee is funded by central government. So just consider what's going on here. This is a little bit unusual for the Chair and Deputy Chair to be writing publicly to the Secretary of State just prior to designation of the AMPS, expressing surprise that he hadn't made reference to the Paris Agreement. And what we say is that at the very least, it doesn't imply that the Climate Change Committee were overly impressed with the approach being taken by the Secretary of State. It rather implies the contrary. I'm conscious that I'm approaching the end of my time slot. Just two things left to do, and I've only got time to deal with this very briefly.
Thank you, Mr. Crossland. We do, of course, have your written submissions, which, if I may say so, are very clear, and we've taken those on board.
Many thank you, my lord. So just before concluding, I will deal briefly with a point raised by Lord Anderson yesterday. He suggested we couldn't argue a point based on the Human Rights Act, Section 3, because we don't have permission for it and it's a separate ground. We say it's not a separate ground at all. It's nothing other than an additional argument in relation to ground 1. It's an argument about the improper interpretation of Section 5(8) of the Planning Act. And in any event, the rules of the Supreme Court state 25, a respondent who wishes to argue that the order appealed from should be upheld on grounds different from those relied on by the court below must state that clearly in the respondent's written case, which we've done but need not cross appeal. What is required is that an intention to rely on the Human Rights Act should be notified to the parties in Form 3. And if we turn to the bundle, core bundle, page 52, you'll see that that is exactly what we did in June. We stated that we intended to rely on HRA Section 3, and the first we heard from Lord Anderson that he had a point around permission was yesterday. Just very briefly, what we say is this. The court has already seen that in the view of the government, climate change is an existential threat. We've seen from the Paris Agreement decision signed by the UK government the threat of irreversible damage to people and planet. We've seen in the government's clean growth strategy the statement that beyond 2 degrees, those risks become intolerable. It's clear there is a risk to life and to home from the climate crisis. This is already happening. We see it all the time. The wildfires in Surrey forcing people to leave their homes, the floods around the country. There's no question of the impacts that are already being felt. What we say is, if this court were to interpret government policy in such a way that said the Secretary of State ought not to have regard to the limit that has been assessed as maintaining those risks to a tolerable level, and to the contrary, he should use instead the discredited 2-degree limit, which is the logical consequence of saying he should not have used the Paris temperature limit. What this court would be requiring secretaries of state to do in the future is knowingly disregard the limit accepted as keeping risks to a tolerable level, and to use instead a limit that has been rejected as dangerous. And in our submission, that would be inconsistent with the interpretive provision of the Human Rights Act. That would create, by this court's decision, unnecessary risks. We'd be asking for the wrong benchmark to be used. That, in essence, is our submission on that point. We say, actually, it's fairly trite law. It's well known there's a positive obligation on the government to take reasonable measures to safeguard the right to life of those within the jurisdiction, and that must surely include reference to the correct global temperature limit, not to the wrong one. That is our point. We make it only because of what we say is the very unusual nature of Hal's submission, which by implication is that it was perfectly okay to use the wrong limit, but not the correct limit. Just coming to a conclusion, my lords and lady, absolutely acknowledge, the persuasive value of Lord Anderson's submissions yesterday. In many ways, from our perspective, horribly compelling and persuasive. But they were submissions based on an alternative set of facts. They were submissions not based on the facts before this court. Lord Anderson's submissions assumed that the ANPS was assessed against the Climate Change Act, Section 1. It was not. And it was not because that section specifically excludes aviation emissions. His submissions were based on the assumption that the planning assumption was government policy. As we've seen, it was not. And his submissions were based on the premise it was simply not practical or feasible to assess the ANPS against a global temperature limit. Well, as we've seen from the Secretary of State's own witnesses, that was just not true because it was assessed against the global temperature limit. Caroline Lowe made that quite clear. It was assessed against the 2 degrees. So Lord Anderson's submissions are simply undermined by the fact they proceed on a false factual premise, a misinterpretation of what's occurred. May have noticed Lord Anderson referring yesterday to Plan B in Friends of the Earth. I think his words were, as they describe it, the climate emergency. Just a quick correction to that. You'll see it in the chronology. It's not our terminology. The court isn't interested in our terminology. On the 1st of May 2019, it was our Parliament, the UK Parliament, that declared a climate and environmental emergency. So that is Parliament's terminology, not ours. We've seen that far from being formulaic or a process point, according to the Department of Transport's own evidence, application of the Paris temperature limit implied net zero aviation emissions by 2050. That would have posed obvious implications for the ANPS. And in our submission, we say it was plainly unlawful for the Secretary of State to interpret Section 5.8 in that way. Just one final point, my lords and ladies, quite properly, this court does not operate in a vacuum. This moment, as we've seen, as the UK approaches COP26, the next critical stage in the UN process, the UK's leadership, nothing could be more vital than that. And what we say is if the UK, which has adopted this leadership role in the run-up to COP26, if the judgment coming from the UK's highest court says for the purposes of Section 5.8, actually the Paris Agreement temperature limit isn't government policy at all, and it was perfectly okay to use instead the old historic 2-degree limit, that doesn't leave the UK in a good position to do what it said it needs to do as part of its policy and part of its diplomatic efforts. It would be the worst possible start to the run-up to COP26. It is government policy to influence using its leadership, and that's why it's expressed such clear and unequivocal commitments to the Paris temperature limit. Thank you, my lords. Lord Leggett.
I'd just like to come back to the issues in the case, if I may, Mr. Crossland,
Of course.
and ask you a question following up what Lord Hodge asked you. Suppose we were to accept your submission that the government's commitment to the Paris Agreement targets amounted to a government policy within the meaning of section 5.8. And suppose that the national policy statement had included in it a sentence or two to say, we have in mind the fact that in the light of the Paris Agreement, the carbon targets may need to become more demanding in the future. But we've taken account of that in setting the statement by providing that the development consent shall be assessed against the current carbon targets, whatever they are at the relevant time. Would you accept that that would have been a sufficient explanation to render the statement lawful? And if not, why would that have been deficient on your case?
So, see, a lot goes into this, and a lot goes in from the developer's perspective into making a submission for development consent. And so what everybody wants at the AMPS stage is some clarity on the overall position. And what we say is that having looked at the Department of Transport's own evidence about the implications of the Paris Agreement and the need for aviation emissions to reach net zero by 2050, what was needed was some explanation of how the AMPS could be reconciled with that position. That's what Parliament needed. That's what everybody needed, because what people were being told was there was simply no issue with the government's obligations. They'd looked at the international obligations, they'd looked at domestic law, it was all perfectly consistent. And what we've seen is actually it wasn't consistent at all. 40 million tonnes of carbon dioxide by 2050, whereas Paris says no emissions by 2050. So had the Secretary of State done what he ought to have done, he simply couldn't have told Parliament that everything is okay, this is all completely consistent with our international obligations as well as our national obligations. And the process then might have been quite different. It's not for us to second guess that. We can't know what the vote would have been in Parliament. We can't know what any other decisions would have been. If the Secretary of State had said to Parliament, I need to level with you here, there's a real tension between our commitments under the Paris Agreement, which imply a radical reduction of aviation emissions over the next 3 decades, whereas the AMPS is going to increase our emissions. It's going to take us in the opposite direction. So nobody's suggesting that Section 5.8 obliged the Secretary of State to follow the Paris Agreement. It's a reasons obligation. It required him to be transparent with everyone. When Parliament were relying on the Secretary of State to tell them there was this tension between the Paris Agreement and the AMPS. But he didn't tell them that. He said, everything is okay.
Well, thank you very much, Mr. Crosland. I think we had better turn now to hear Lord Anderson in reply.
Thank you, my lord. Thank you, my lord.
Thank you, my lord. I propose to take the points pretty much in the order in which they were made. I'm going to start with 3 points Mr. Wolf took on the ANPS, and perhaps I could ask you to turn that up, page 1760. This is the page with the heading Climate Change Adaptation. And you'll remember Mr. Wolf took a point, I don't think I noticed it in his case, but that might be my fault, to the effect that the ANPS at 1760 and 1761 considered only the desirability of climate change adaptation and not climate change mitigation, which he rightly pointed out was a very important aspect. He's right, of course, that section 10.3, which is footnoted to paragraph 4.41, requires regard to be had to the desirability of both mitigating and adapting to climate change, and the two words also appear in section 5. He's also right that the heading on page 1760 reads simply climate change adaptation, and that the main thrust of this section, consistently with that heading, is about adaptation to deal with these potential impacts. But 2 points. I'll start with a smaller one. There is reference in the section to the need for mitigation measures, albeit not at the same length. So in 442, it said that climate change mitigation is essential, and it's explained why. At 446, over the page, it said that detailed consideration must be given to ensuring that any environmental statement that is prepared identifies appropriate mitigation or adaptation measures. Then the second point, perhaps more significant point, is that there is a section elsewhere in the ANPS that is headed mitigation. So if you would turn on to page 1767, that'll be a familiar section by now to the court. It's a section headed carbon emissions. You've already been taken to 576 at some length. But if you go over the page to 1769, you see that on that page, there is another section headed mitigation. Now, it appears in section 5 of the ANPS because section 5 is about impact, and mitigation is relevant to the size of the impact. But if you look, just don't have to read it in detail, but if you cast your eye down through this section, you will see at the start the Secretary of State will need to be satisfied that the mitigation measures put forward by the applicant are acceptable, including at the construction stage, and then various expectations are set out. So at 578, you see various measures to limit the carbon impact of vehicles, aircraft on the ground, buildings, access arrangements, public transport. 579, cleaner aircraft, lower emissions from flights. 580, mitigation measures at the construction stage. So really, there is nothing, we say, in this point. Going back to 569, the first paragraph of this carbon emissions section, Mr. Wolf took a point on this. There's a reference to a number of international and domestic obligations to limit carbon emissions, and he said that those obligations do not include Paris. As Lord Sales put to him in questioning, that is, with respect, a difficult argument to sustain in the light of Articles 3 and 4 of the Paris Convention, which require the parties, and I quote from Article 4, to aim to reach global peaking of greenhouse gases as soon as possible, to undertake rapid reductions thereafter, to achieve net zero in the second half of the century, and to make and communicate ambitious efforts by way of successive nationally determined contributions, which are ratcheted. Those surely are international obligations to limit carbon emissions. Indeed, if he were right that Paris contained no obligations of this kind, then how can it be the type of mandatory material to be considered that he contends it is under Section 10? Mr. Wolf then went forward a bit to what he called the stop-go test under 582 on page 1769. This is the passage that says any increase in carbon emissions alone is not a reason to refuse development consent unless that increase is so significant that it would have a material impact on the ability of government to meet its carbon reduction targets, including carbon budgets. That's the future-proofing section to which we both referred. And what he described last night as his main point was that if Paris had been taken into account in formulating the ANPS, that test might not have been framed in that way. But there was no substantive indication, whether in answer to questioning from your lordship's ladyship or otherwise, of how that test would have been framed. And notably, Mr. Wolf does not argue that Paris could have been material in some other way. For example, that the ANPS would not have supported the Northwest runway at all. Paris requires successive, nationally determined contributions. And in the case of developed countries, it requires economy-wide absolute emission reduction targets. Our own system is consistent with Paris, and indeed, as I think all advocates have said to the court, was one of the inspirations or the templates for it. So to take account of Paris in the preparation of the ANPS would simply have confirmed the system of targets and budgets that was alluded to in 582. Indeed, what this submission and the parallel submissions of Mr. Crossland fail to allow for is the fact that the Climate Change Act system is not opposed to Paris, it is consistent with Paris. Through its mechanisms for adjusting targets pursuant to sections 2 and 3, and for setting successive carbon budgets under section 4, it provides the domestic means for implementing our international climate change obligations, and it is flexible enough to cope as those obligations change or as policy decisions are taken as to how to comply with them. There was, I think, a suggestion this morning from Mr. Wolf that perhaps things would have been different in that had Paris been taken account of at this stage, there would have been a decision to pause, or could have been a decision perhaps, to pause the issue of the ANPS. To that we'd say, well, the Secretary of State clearly considered the matter and decided to push on despite suggestions that he should pause, and this after the detailed consultation in which all sorts of reference was made to Paris. That was explained in correspondence with the Climate Change Commission, to which reference has been made. In fact, I might just take you to that correspondence now. Mr. Crossland referred to it towards the end of his submissions, but since we're not too far away, it's at 1625, the initial letter from the CCC. This is the one Mr. Crossland described as unusual. If you have that letter, it's the letter signed by Lord Deben, former John Gummer, the 14th of June 2018, and it does indeed express surprise in the second paragraph that a statement to the House of Commons didn't mention the Paris Agreement or indeed the Climate Change Act. The surprise is expressed on both grounds. You can see what they wanted from the last paragraph over the page. We look forward to the department's new aviation strategy in 2019, which we expect will set out a plan for keeping UK aviation emissions at or below 2005 levels by 2050. And to inform your work, we're planning to provide further advice in spring 2019. And then the reply to that letter is at 1713, an emollient reply, which I don't take you to in detail, but if you look over to 1714, you see strong emphasis placed again on the aviation strategy. As part of the development of the aviation strategy, the government is considering, among other things, putting in place a framework for UK aviation carbon emissions to 2050, which ensures that aviation contributes its fair share to action on climate change. And then I think the other document that is relevant to the pause is the cabinet note that I referred you to in opening. Perhaps not. Perhaps I'll come back to that if it's right. No, I think it is. It's page 1717. So just a little bit further on. Yes. This is the cabinet note from the Secretary of State to his colleagues. It's at the bottom of 1717, paragraph 17, and it's about the Harrison Grant correspondence, in which they asked the government to reconsult following the publication of the CCC progress report to Parliament, expected on the 28th of June. We do not consider there is any need to undertake the further consultation suggested. This is because the proposed airport's NPS is clear. No material impact. That an increase that would have a material impact would be a reason to refuse development consent. In any event, wider policy considered as part of the aviation strategy. Oh, I'm so sorry. Yes, that's a ministerial submission, which I didn't take the court to in opening. Perhaps I should have done. Perhaps it doesn't matter very much. But that's the document anyway. The submission to ministers. I'm sorry, I confused it with the document that the minister himself produced for the cabinet. Yes, and I'm very grateful to Mr. Humphreys. There is a specific reference to the pause. I don't think I need to take you to it in reply, but you've seen it before. It's at 1592, and it's the government response to the consultations on the ANPS, which was published in June 2018. And it's the passage cited also at paragraph 88 of our case, to the effect that you simply cannot delay things indefinitely until every potential future duck is, so to speak, in a row. Lord, going on to ground 2, it's striking how much effort was devoted to the first part of this ground, principally to suggesting we weren't entitled to raise it at all, which I perhaps unkindly described as a pleading point, but I'm not sure what else it is. And then on the merits of the point that the Court of Appeal was wrong to conclude on the basis of the evidence before it that legal advice had been received by the Minister and what the content of that legal advice was. Our submission is that, and it's an understandable line to take, Mr. Wolf fought extremely hard on the first part of ground one, both on the pleading point and on the ground itself, because of the extreme weakness of the Court of Appeal's conclusions on the second substantive part, and therefore of his position in seeking to defend it. But may I deal with the pleading point very briefly? I think there are really 2 points to be made on it. They've both been made in questioning from the court by Lord Legate and Lord Sales, so I shan't labour them. The first point is Mr. Wolf has been on notice of this point since our case was lodged in August. There's been no conceivable prejudice to anybody, and none was suggested. So it really is the most technical of points. And the second point is that the challenge to, if you like, part one of ground two is implicit anyway in the way we put our application under ground two. It's page 25 of the electronic bundles. Ground two, as they're expressed, concerns the status of Paris. Was it a mandatory material consideration? That ground would make no sense if this court were stuck with the conclusion that no discretion was ever exercised, whether on legal advice or otherwise. So clearly implicit, at least in ground two, ground of appeal, is a rejection of the threshold point at paragraph 236 of the Court of Appeal. Turning to the point itself, still on the first part of ground two, we made essentially two submissions. First, there is not the slightest evidence that the Secretary of State had the legal advice alleged or that he acted on it. Certainly it does not appear from the material cited in support by the Court of Appeal, which is paragraphs 218 and 220. I'd remind you that 220, which cites the email from the clerk to Mr. Justice Holgate, albeit one suspects Mr. Justice Holgate might have had a hand in the drafting, predated the amendment of the detailed grounds of resistance. Indeed, it was this that prompted the amendment, and I showed you the pleadings, paragraph 63, we say very clear. And then secondly, we say even if he had been given that advice, it would not follow logically, as the Court of Appeal seemed to assume at 236, that he did not also address himself to the issue of discretion. Indeed, it's very clear from the Secretary of State's evidence, that's the evidence of Miss Lowe, the senior official, Miss Stevenson, the consultant, working on the project at a very senior level. It's clear from his pleadings, clear from everything quoted in the Statement of Facts and Issues at 11 to 13 and 67 to 69, that he did exercise that discretion. Speculation about what legal advice he may have received, we suggest is not a fruitful exercise, but if one were to infer anything from those documents, it would be that he believed he had a discretion, or at least might have a discretion. So exercised it on that basis. To overcome this difficulty, Mr. Wolf prayed in aid paragraph 638 of the Divisional Court, in which Mr. Morici for the Secretary of State is recorded as submitting that the Secretary of State is required to ignore international commitments except when they are expressly referred to in the Act. But the fact that Mr. Morici made that legal argument in March 2019 is not evidence of what the Secretary of State was advised prior to June 2018, and indeed was not relied on by the Court of Appeal for that purpose in the paragraph that Mr. Wolf defends, 236. Then, as also recorded in 638, Mr. Morici went on to submit that even if he was not obliged to ignore Paris, the Secretary of State was not obliged to ignore Paris, he had a discretion as to whether to do so. So even if one were to make the giant leap of equating Mr. Morici's submission with the advice previously given to the Secretary of State, it would follow that the Secretary of State had been advised, at least in the alternative, to exercise his discretion, as the evidence makes perfectly plain that he did. The reality is, as the contemporaneous documents make clear, that proper consideration was given as to whether to have regard to Paris, and it was concluded for clearly expressed and rational reasons not to do so. Well, on the substance of ground two, not much was said. It's the issue unreasoned by the Court of Appeal at 237 of the obvious materiality of Paris. You've heard a great deal from all advocates about that topic, but in our submission, it is simply unsustainable in view of the relationship that we've discussed between the Paris Agreement and the legal and policy position as it prevailed in the UK. And in particular, it is not obviously material, and here we get onto the territory of the so-called concession, to exhume emerging materials on what Paris should in the future mean for policy. It was said that the Secretary of State, I think by Mr. Wolff, it was said that the Secretary of State conceded that there was material which might have led him to a different answer. I tried to make the point in opening that if you read that concession properly, as it's set out in that pleading, paragraph 63, it's not what it said. Rather, the issue was being taken out of the equation. The Secretary of State was sufficiently confident of his primary position that he saw no need to place reliance on that. Indeed, perhaps it was more a helpful narrowing of the issues, as Mr. Justice Holgate put it, than a concession. Of course, there was emerging material internal to government. One would hope there would be once a major international convention had been adopted and signed and ratified. But you cannot say that the moment civil servants begin their blue sky thinking, if that's probably not an appropriate phrase in this case, the Secretary of State is bound to start taking it into account. That would be a recipe for chaotic government. One has to allow a policy to emerge. It may, of course, be that that material will lead to stricter policies, but that's the context of that concession. On ground 3, again, the start of Mr. Wolff's submission was to take you to 245 of the Court of Appeal's judgment and to summarize the submission of Mr. Morici as being limited to the ground of relevance. But as Mr. Wolff accepted on the construction of the directive, there are two stages to the analysis. There is the stage in Annex 1 of relevance, and there is a stage in Article 5 of whether the material is reasonably required. And Mr. Wolff quite correctly accepted that reasonably required was, as he put it, more open-textured. In fact, I don't think he really addressed any argument to the court to the effect that if reasonably required was in play, then applying the Wednesbury test, as he accepted was, or the Blewett test, as he accepted was required, he could prevail on it. Instead, he takes once again the procedural course, and he tries to bind us to arguing only relevant, and he tries to derail the whole ANPS on a basis that no doubt fairly junior official did not include an agreement that everyone was well aware of in a scoping report that was yet to be subject to consultation. In relation to consultation, you'll remember that that was Mr. Justice Sullivan's point in Blewett, where he said the consultation acts as a check, and that's why one can't expect these things to be perfect right from the start. And as regards the specific omission of the Paris Agreement, he drew the comparison or the contrast to the Kyoto Protocol, which of course was referred to, as he pointed out, in the scoping report. But it really doesn't help him. The Kyoto report, as I tried to explain in opening, contained a specific carbon target for the UK. That was the route that was taken in Kyoto and that would have been taken in Doha had it ever entered into force. And then the second point is, well, Kyoto was, of course, in force at the date of the scoping report in March, I think, 2016. At that point, the United Kingdom, it's true that Paris had been adopted, but it hadn't even been signed by the United Kingdom or by anybody else. That followed in April, or ratified, which followed later in the year. reasonably required was raised by us, and not only by us, but by the Secretary of State below. And I took you to that in opening, so I'll just very briefly give you the references again. Yes. Oh, I'm so sorry, Lord Legate. Yes.
I thought that Mr. Wolf's point was that, as a matter of fact, he said, the Paris Agreement was ruled out at the relevant stage, so that the Secretary of State never got to consider the reasonably required question. There might be causation points, but he's saying it was an error of law to rule it out at first base. And what do you say in reply to that?
Well, we say precisely the point Mr. Justice Sullivan made in Blewett, that this is an iterative process, and that the consultation process is designed, if you like, as a check on the initial formulation of more than 100 instruments. So it would have been open at any stage to classify the Paris Agreement and to decide whether or not it was reasonably required. Plainly, as it was raised by all those tens of thousands of consultees, that was something that the government was able to do. But of course, we make our point on relevant as well as on reasonably required. The points I took distinguishing Paris from Kyoto are reasons why it was rational to accept the relevance of Kyoto and not the relevance of Paris. And of course, all the grounds we take on ground two apply as well, really mutatis mutandis, for the fact that the Paris scheme is reflected in the Climate Change Act scheme. So we don't shy away from relevance, but we do also make the reasonably required. I take entirely the point the Lordship has made. Perhaps in the light of that, I don't have to remind you of what we said before about how reasonably required was raised by Mr. Morici. See that from Court of Appeal 135, and it was raised in our skeleton argument at 747.
Mr. Anderson, could I ask you a question about that sequencing? Because I thought that there was reference in Stevenson's witness statement in particular, in essence, in the same passage where she explained that the advice of the CCC was followed to explain why the Paris Agreement was not referred to in the environmental report as well. But am I wrong about that?
No, I think Lordship's quite right. I have it at paragraph 3.128. It's recorded in, it's 824, and it's recorded in the ASFI at 68. Is that where she says at this stage it is not possible to consider what any future targets might be recommended, what, if any, I think that should be, future targets might be recommended by the CCC to meet the ambitions of the Paris Agreement. It's expected that should more ambitious targets be recommended and set through the carbon budgets beyond 2032, then government will be required to make appropriate policy decisions across all sectors of the economy. That's relevant under ground 3 as it is under ground 2.
Yes, thank you.
On Blewett, the court has my submission, and I don't think there's anything between Mr. Wolf and myself on it. And he didn't challenge our case specifically, that it's the Blewett test that applies in addition to the question of relevance. Lord, in relation to this, Lord Reid, in a question, I think to me yesterday afternoon, referred to a line of cases about the adequacy of reasoning in planning appeal decisions, with their emphasis on substantial prejudice to the interests of the applicant. He mentioned the Save British Heritage case back in 1991, and he alluded to other cases, which I think we've identified as the South Somerset case in 1993, in which Lord Hoffman said the inspector is not writing an examination paper, and the Champion case in 2015, in which Lord Carnwath in the Supreme Court said that the EIA process, the environmental impact assessment process, is not intended to be an obstacle race. And I would respectfully agree that those comments do resonate strongly with the present case. The only caution I would enter, and it is a very small one, is that most of those cases are on individual planning decisions or on negative screening decisions under the Environmental Impact Assessment Directive. I suspect, though this may not be of concern to this court, that there is less precedent for the application of those principles to the inclusion of information in an environmental report. In relation to the adequacy of assessment, the established legal test, of course, is Blewett. Assessment is for the decision maker, subject to Wednesbury review. But in determining whether the test for judicial intervention is met, we would submit that considerations of who the document is intended for, what sort of knowledge is to be expected, and so on, are certainly material, as is the strong public interest in not requiring decision makers to write examination papers or complete obstacle courses. And indeed, the perception that courts are in the business of erecting obstacle courses and penalising those who run them for not doing so perfectly is precisely what Mr. Justice Sullivan had in mind in the passage cited at the Court of Appeal, paragraph 126. It's paragraph 41 of Blewett, when he said, in an imperfect world, it is an unrealistic counsel of perfection to expect that an applicant's environmental statement will always contain the full information about the environmental impact of a project. The regulations are not based upon such an unrealistic expectation. They recognise that environmental statement may well be deficient and make provision through the publicity and consultation processes for any deficiencies to be identified, so that the resulting environmental information provides the local planning authority with as full a picture as possible. There will be cases where the document purporting to be an environmental statement is so deficient that it could not reasonably be described as an environmental statement as defined by the regulations, but they're likely to be few and far between. So we respectfully agree, and I say so having, of course, discussed the matter with Mr. Humphreys and Mr. Turney, that the suggestion of Lord Reed that these two lines of case law complement each other is a good one. And in looking at whether a lack of relevant or arguably relevant information is reasonably required, or indeed looking at whether it's relevant in the first place, it makes perfect sense to consider who is likely to be reading it and whether they would have been in any way prejudiced by that information not appearing, for example, in a scoping report. Lords, I go on to ground 4 and to briefly, first of all, the post-2050 point. Mr. Wolf said that the failure was to put that matter into the statutory context of Section 10. But as the court knows, the Secretary of State did not fail to look at post-2050. He considered carbon impacts over an assumed 60-year lifetime of the project, which on any view was a rational timeframe for assessment. So it cannot be said he left it out of account or failed to put it into the context of Section 10. The complaint at its highest is that the consideration didn't bear the badge of Section 10 on it. It's a complaint of form and not of substance. I had a reference, yes, it's to 1670 and 1671. Don't take you to them, but those are the pages of the appraisal of sustainability where you see the references to post-2050. On non-carbon dioxide, Mr. Wolf, I think, perhaps I had this wrong, but I think he started by saying the Secretary of State did not take account of non-carbon dioxide at all. Well, we don't accept that characterization. It was, of course, considered, but the Secretary of State then decided that nothing should be done with it because it was not capable of quantification. And the references, which I think I've taken you to, are at 105 brackets 4 to our case, and they're at electronic bundles 1671 and 1703. So far as the main substance of the point is concerned, there was overwhelming evidence from a variety of sources that the correct course was to keep non-carbon emissions under review and reassess the UK's policy position as more evidence became available. We've set out the references to that evidence at 114 and 116 of our case, and I don't think there's any point in taking you back to those. But as Friends of the Earth's own witness, Mr. Johnson, put it, that's one of the references, 105.1 of our case, in paragraph 52 of his statement at 850. scientists continue to explore metrics to show how non-carbon dioxide impacts can be reflected in emissions forecasts for policy purposes. That, on Friends of the Earth's case, is how far we'd got. Not only no accepted quantification of the effects, but no accepted metric for quantifying it. Once again, therefore, no sensible suggestion of what a meaningful taking account would have looked like, what policy could have been built on the basis of what we had. We all know there are contrails in the sky. We're aware they don't last very long. We're still grappling with the whole business of trying to work out what impact they might have on the warming of the planet. So the Secretary of State was fairly informed of the potential significance of non-carbon and was entitled to proceed on the basis of that expert advice. Reference was made to the Brundtland criteria, which were referred to at the Divisional Court, paragraph 635. I'd simply remind the court that that paragraph refers also to the IPCC, the NPPF, the National Planning Policy Framework of March 2012, which, as the Divisional Court records, goes on to say that achieving sustainable development means that a planning system has an environmental objective, but also an economic objective and a social objective. So they have to be pursued in mutually supportive ways. Well, I'll come back at the end briefly to the question of relief, but may I go on now to Mr. Crossland's points. He made some points on the planning assumption. He said that the ANPS was not based on the Climate Change Act because of the planning assumption, and he said that the planning assumption was not part of government policy. Lords, my lady, we don't accept that. On the planning assumption, I explained the position in opening as summarized by the Divisional Court in paragraphs 570 and 574, and I think also by the Court of Appeal in 217. The planning assumption, the point about the planning assumption, whether or not it's, and the government prefers planning assumption and others prefer aviation target, and I accept there may be some sensitivity about precisely how it's characterized or referred to, but the practical point is that the planning assumption does inform the carbon budgets adopted under the Climate Change Act, as the Divisional Court explained by reference to Section 10 of the Act. It's taken into account by this concept of headroom. They work out what the budget would have been to achieve the CCA target. They then deduct the headroom, and the declared budget in the statutory order declaring the budget is the balance. In other words, the budget for everything else is reduced to accommodate international aviation, even though under the letter of the law, international aviation is excluded from the budget. Now that's it's a roundabout way of doing it. The government keeps saying they want to look again at this, and no doubt the aviation strategy will look again at it. But one simply cannot say that the international aviation is excluded, or that the planning assumption is excluded from the CCA scheme. It's implicit in the way that the whole scheme works. Then, yes, I'm so sorry, Lord Legate. I should say, I should apologise that entirely through our own fault, we can only see 4 of Lordships at any one time, and it seems to be a slight lottery as to which one we can't see. So if I don't respond, it may simply be that whoever it is not visible.
I'm sorry if I disappeared, Lord Nansen, but I just wanted to ask how far you take this point. I mean, do you say that a change in the planning assumption would have been unlawful because it would have been inconsistent with the decisions taken under the and budget target set under the Climate Change Act?
So you're asking whether a change in the planning assumption
Would have been unlawful because inconsistent. You say it would have been inconsistent with the duty of the Secretary of State under the Climate Change Act. Suppose they'd used a different planning assumption for the purpose of the policy statement.
May I take a moment? Yes, well, I don't know if you heard that, but it's, I hope what I would have said. No, we don't think it would have been inconsistent. And the planning budget, the planning assumption was devised by the CCC in 2009. I think we had a brief look at the document where that was done. It doesn't increase or diminish the total size of the budget, although it does increase or diminish the amount that is reserved within that budget for other sectors. And of course, it's not immutable. It's subject to review. Indeed, the whole concept of whether one continues with this slightly awkward system, or whether one actually in the future devises budgets into which international aviation is formally baked in, remains an open one. And no doubt the aviation strategy will have something to say about that. Yes, Lord Sales.
But it does seem to have a tension, doesn't it, with that part of your case where you say that changing the emissions budgets and caps outside the Climate Change Act would be unlawful. This is paragraphs 42 to 45 of your case, because that seems to be what has happened by the adoption of the planning assumption, which is something excluded from consideration directly under the Climate Change Act, see section 30, subsection 1. And yet somehow this back route method, which has been found to satisfy the CCC, without well, I don't know, would you say that it's been implicitly endorsed by Parliament, because for the carbon budgets which reflect the planning assumption, they've had to be changed by going through the affirmative resolution procedure under section 5, I think it is.
Yes, indeed, that's right. They do go through the affirmative resolution procedure, so we would make that submission. There's also section 10 of the Planning Act to consider.
Sorry, Lord Ansel, I thought you just accepted in answer to my question that it wouldn't have been unlawful or inconsistent with the budget to change the planning assumption.
No, it wouldn't.
Well, then,
so
sorry, I haven't followed how your answer to my question is consistent with your answer to Lord Sales's question.
Well, I understood Lord Sales's question to be on a different point, which was our point that government policy is bounded by statute, and yet if the planning assumption is introduced into the equation, that is a sort of rogue non-statutory assumption, which is inconsistent with the submission that government policy is bounded by statute.
Perhaps I could say, my question was prompted by Lord Legate's question, but yes, even as I was asking it, it seemed to me that perhaps the solution was that even if the planning assumption has been taken into account in the preparation of the carbon budget, you only get the carbon budgets on whatever basis by getting them approved by Parliament under the affirmative resolution procedure.
Yes,
and
no,
so
I agree. Yeah.
And so, as I understand it now, there would be scope for the planning assumption to be removed. I mean, the carbon budgets would stay as they are, as endorsed by Parliament at the moment. But in the next round of carbon budget, the planning assumption could be removed and the carbon budget would therefore be increased, I assume, but Parliament would have to endorse that.
There's another point, my Lord, on this, which is section 10 of the Climate Change Act. It's at 1909, and this is the statutory basis, if you like, for the route that is taken by the planning assumption. It's 10 10.2i, one of the things to be taken into account in connection with carbon budgets is the estimated amount of reportable emissions from international aviation and international shipping, the budgetary period or periods in question. And then 10.3, that phrase is defined as the aggregate of the amounts relating to emissions of targeted greenhouse gases from international aviation and international shipping that the Secretary of State or the committee estimates the United Kingdom will be required to report for that period in accordance with international carbon reporting practice. So that is the statutory provision that yokes, in a sense, compensates for Section 30 and yokes international aviation into the Act. Yes.
Just waiting to be unmuted. Right, that's very helpful. I follow that route as well. But can I just press you on, well, it's really paragraph 45 of your printed case, and how wide the sort of Miller and Decazes Royal Hotel point goes based on the Climate Change Act. Because given the strong will within government to do things to mitigate and adapt to climate change, one might have thought that there would be all sorts of policies that government could adopt outside the Climate Change Act, which would be relevant to mitigating or adapting to climate change. And indeed, from memory, I think that the NPPF includes policies which are directed to mitigation and adaptation to climate change, and the NPPF is, I would have thought, a paradigm example of government policy. It would be surprising if that were made unlawful, i.e. those parts of the NPPF, by the point that you're making in your paragraph 45. Yes, and I just wonder how you put the boundary. What's the boundary?
Yes, it wasn't intended to go that far, my lord. I mean, we put the boundary the way we put it at 42, which is where we begin this section. No such policy could have overridden the applicable statute. In other words, what you cannot do is come up with a policy which implicitly replaces what Parliament has decided should be the position. So the whole idea that 2 degrees is outdated and something should have been based on 1.5 degrees in the ANPS, it's almost a sort of a fire brigades union point. It would have subverted the statutory scheme, and that's what you can't do. And it's what the planning emission, what the headroom, the aviation target, planning assumption doesn't do, because that is something that is plainly envisaged in the Climate Change Act, as well as endorsed by Parliament every time a budget is set.
But if you go back to my example of, for instance, the NPPF, assuming it does include guidance on mitigating against climate change and so on, are you saying that it wouldn't be open to the government to tighten up the NPPF with a view to being more ambitious than they're seeking to be under the Climate Change Act itself?
Are you
taking steps around the edges to mitigate and adapt to climate change on, if you like, a more aggressive basis?
Are you speaking specifically about carbon targets, for example, sectoral carbon targets, or about which obviously is something that's governed by the Climate Change Act? And on that, our point really is made by the CCC, and it's on the section you've taken me to of our own case, page 121. At footnote 19, where the CCC wrote to the Secretary of State and said that 80% should be regarded as a minimum average target for those sectors covered by the bill, with further reductions required if international aviation and shipping emissions are not on track to deliver an 80% reduction. So there's obviously some flexibility there. There may also be other. Yeah.
So I'm sorry, my question wasn't specifically directed to carbon targets, but there may be all sorts of policy initiatives that government might want to take if it wanted to be more ambitious than the position currently obtaining in relation to carbon targets. Yes. So, for example, going back to the NPPF example, in terms of mitigating against climate change, one might have a certain level of mitigation predicated on what was implicit or implied by the carbon budget that we've got at the moment. But ministers wanting to be more ambitious than that or more pessimistic, if you like, in terms of where they think climate change is going, and therefore introducing enhanced mitigation obligations as a matter of planning policy, not specifically by reference to carbon targets, but against the background of an implied assessment that the carbon targets may have been overtaken.
Yes. What one can't do is simply take at least 80% as license to for ministers to decide that we're going to go for 90%. I mean, this has to be done by the proper statutory procedure, which is in sections 2 and 3, and that's our answer to what the Court of Appeal said about that. You know, I'm reminded the point of the 37.5 megaton planning assumption is that it remained the CCC's advice at the time of designation. So there's nothing, you know, nothing rogue about that. But no, our submission doesn't go any further than we express it at 42. And we're trying to meet the case made against us, which is that this 80% was ridiculously outmoded and outdated because it was based, as indeed it was based, on an attempt to limit temperature rise to 2 degrees. And we're saying, well, you can't just play around with carbon targets based on different temperature rises unless you've gone through the statutory procedure that Parliament provided in sections 2 and 3 of the Climate Change Act. That's all we're saying in this section.
All right, thank you very much.
Thank you.
I think Lady Black also has a question for you.
Oh, yes.
It's just about the inclusion of the words "at least," which you, I think, would say has a limited role. It's Section 1 imposes a duty on the Secretary of State to ensure that the net account is at least X% lower.
Yeah.
Why doesn't that allow him to introduce a more stringent target? You said 90% wouldn't be acceptable. Why not?
Well, we'd rely on the Fire Brigades Union principle. If Parliament, in an Act of Parliament, has set out a procedure for something to be done, then it's not open to the Secretary of State to seek to achieve the same result by other means.
But it's at least 80%. Yeah. It isn't to fix it at 80%. Now, I can see why you can't make an imposition on the Secretary of State to achieve 90%, except by the means set out in the Act. But why can't it go for a bigger reduction without going through a process?
If I could answer this by reference to our case, it's paragraph 44, the same page we've been looking at. We say the fixing of the statutory target as at least 80% gave the necessary flexibility to permit a presumably desirable overshoot and to accommodate the different needs of different economic sectors. And that's the point made by the Climate Change Commission in the letter that we footnote. But it doesn't mean that the government was entitled to substitute a higher target without going through the procedure in sections 2 and 3. And as we say there, if that were the position, then the amendment procedure in sections 2 and 3 would be expressly limited to downward amendments, which it isn't. In fact, when in 2019 they did decide, having heard from the IPCC and having heard from the CCC to adopt a higher target, they did follow that statutory amendment procedure. And of course, we all want to stop global warming or climate change. Of course we do. But as we say at 44B, 3B, the fact that the same procedure is required for upward and downward amendments does underline the careful balance that has to be struck between economic development and environmental protection. There are risks both ways, and that's why this decision was entrusted by Parliament to Parliament under the statutory amendment procedure.
I can see all of that if it said to 80% lower, but the inclusion of the words "at least" rather weakened that argument. But anyway, I understand what you say about it.
Well, you see what we say about "at least," and you see what the Court of Appeal said, and that's really our submission on it. There was a reference to a Claire Perry statement in Parliament at page 1587. I simply make the point that this was an answer to a question on offshore wind, not a question on UK climate change policy. Mr. Crossland moved on to the CCC advice, and in that context to the consistency of ANPS with Paris, which is a section of our case 46 to 49. There was some argument yesterday with Mr. Wolf about whether it did properly form part of the ground one analysis, but on any view, plainly in Mr. Crossland's case it does, but on any view it's relevant to other grounds, as we sought to explain yesterday. I took you through the Climate Change Commission advice of 2016. It's a bit of an intricate exercise. I won't do it again, but I'll simply remind you of the page numbers: 1364, 1367, 1368, 1372, in support of the idea that even the existing 80% target was potentially consistent with Paris. This is something Lady Black asked about. And that, in our submission, is made even more clear. It is clear from the CCC advice, but it's made even more clear from the document of mid-2018 produced by the CCC in the context of the Plan B litigation. It's the one Mr. Crossland referred to as having possibly been drafted by Mr. Gordon, although if so, he was too modest to sign it. Could I just take you, because it is a very important document, not because it says anything new, but because it summarizes what the Climate Change Commission itself thought it was saying in 2016. So if I could take you to 1811, where that document begins. And then to 1813, the last two lines of that page. In considering the implications of Paris for the UK's 2050 target, it's necessary to translate the temperature goal into the agreement to what this could mean for UK emissions. Having considered this in our 2016 report, we noted that the UK 2050 target is potentially consistent with a wide range of global temperature outcomes. The CCC recommended no change to the existing UK 2050 target, not because a more ambitious target was infeasible, but rather because the existing UK target was potentially consistent with more ambitious global temperature goals, including that in the Paris Agreement. So Lady Black was absolutely right to say that that was the CCC's position. And I don't take you to them now, but one sees more in the section at paragraphs 25 to 27. There was reference to the correspondence between the CCC and the Secretary of State, but we've looked at that. I think before going briefly to relief, and I do apologize, we've run over by a couple of minutes. Perhaps I could have 3 or 4 minutes more just to complete the submission.
Yes, we have been held up by some technical problems.
Yes.
Just proceed.
Thank you. I'm very grateful, my Lord. So may I then come on to the human rights point raised by Plan B? I made our points in opening on the absence of permission to apply, and I showed the court that the argument was expressed as a distinct ground by Plan B, treated as such by the Divisional Court, which refused permission to apply on it. Mr. Crossland understood that if permission is refused by the High Court, then you need to appeal that refusal to the Court of Appeal, and that wasn't done. No one suggests that there was any reference to human rights in grounds of appeal, in written argument, oral argument, or judgment. So in our submission, permission to run the point having been expressly refused, it should not be open to Plan B to reintroduce the point, even under the guise of a response to our ground one, which is how it is introduced. We accept what Mr. Crossland says about the Supreme Court rules. Rule 25.1 says that a respondent need not cross-appeal if it wishes to ask this court to uphold the order of the court on grounds other than those relied on by the court below. But we don't accept this can apply in circumstances where the point has been definitively determined to be unarguable at an earlier stage of the litigation, definitively because no appeal in respect of it was brought. But in any event, the point, whether properly raised or not, is in our submission a bad one, and the Divisional Court was right to find it was unarguable. Plan B summarizes the point at the end of its treatment at paragraph 105 of its case. And if you look at that paragraph, which is on page 211 of the bundle, you see that the point has 2 elements. First, it is said that a non-human rights compliant interpretation of section 5.8 would preclude consideration of the Paris temperature limit. And secondly, it is said that this would tend to the progression of projects creating an intolerable level of risk to home and to life. Both elements are incorrect. I take them very briefly in turn. First of all, the point that a literal, if you like, interpretation of Section 5.8 would preclude consideration of the Paris temperature limit. No one is saying that it would. All that Section 5.8 does is to impose a duty to explain how an NPS takes account of government policy. And as the Divisional Court said at 622, when refusing permission on the human rights point, its meaning is, in that respect, perfectly clear. It doesn't preclude consideration of the Paris Agreement or of anything else once it has the statement of government policy, nor does it in any way limit the scope of Section 10, which, as both lower courts found, and as all parties to this appeal agree, allows the Secretary of State to have regard to the Paris Agreement, whether or not it has the status of policy, if in his judgment or discretion he thinks it right to do so. So we're into Wednesbury. So it's a straw man, the suggestion that it would preclude consideration. It couldn't do that. It's a procedural section. Then the second point is that even if Section 5.8 were interpreted as precluding consideration of Paris, that this would lead to an intolerable risk to home and to life. But no such risk can arise at the ANPS stage. If this argument were a good one, it would only even arguably bite at the development consent stage, not in the context of a prior policy statement regarding the location of a project for which consent might subsequently be applied for. And the tools to deal with it at development consent stage undeniably exist in statute. The Section 6.1 of the Human Rights Act, 2404, which prohibits the Secretary of State from determining any application for a DCO in accordance with the ANPS, if to do so would be incompatible with human rights of any other person who would be a victim under the Act. And that obligation is reinforced by Sections 104, 5 and 6 of the Planning Act 2008, 2063, which clarify that a decision need not follow the ANPS if that would lead the Secretary of State to breach any statutory duty on him, a point I made in opening by reference to the Human Rights Act, or would itself be unlawful by virtue of any enactment. So even if properly raised, the point goes nowhere. Lord and Lady, very quickly, if I may, 2 points on relief, ground 5. On the application of Section 31, Mr. Wolf said on a number of occasions that the burden is on us to make good the no material difference point. Your Lordships and your Ladyship will be aware that there has been a lot of judicial discussion of this provision, and it's probably fair to say that in most cases it will be a defendant who takes the point and then provides the evidential basis to make it good. But it's important just to bear in mind what Section 31 brackets 2A actually provides. The reference is 2407, and it is a question of assessment for the court. What it says is the High Court must refuse to grant relief on an application for judicial review and may not make an award under subsection 4 if it appears to the court to be highly likely that the outcome for the applicant would not have been substantially different if the conduct complained of had not occurred. So it's perhaps a technical point, but I just wanted to make sure your Lordships, your Ladyship were aware of the provision. Then the second point is on exceptional public interest. Mr. Wolf indicated, I think, that the Court of Appeal was not challenged on this alternative ground for granting relief. It's perhaps the final pleading point with which we're confronted in the case. But if there is no other basis for relief, we fail to see how it can be in the public interest for relief to be granted in relation to this policy statement. So we do maintain that challenge. I'm very grateful to the court for the few minutes extra. Unless there are any other questions, those are my submissions.
No, it appears there are no questions. Well, we're very grateful to you, Lord Anderson, and also to Mr. Wolf and Mr. Crosland and those assisting you all for the submissions that we've received, which I think could be described as comprehensive. It's obviously a very complex and important matter. We'll take time now to consider it and let you have our decision as soon as we can. Court will adjourn.